Good morning to all the members of the legal era community. Mr. Vinit, Vice Priest, Dev Vajpayee, Deepak Acharya, and distinguished participants. This Vajpayee gave a long list of wish list of law reforms, which is very daunting because I've been involved in the law making process for quite some time, 3 decades. So I know the intricacies involved in drafting translating a policy into law, then getting it passed into parliament, and it has its own pulls and pressures. But then it doesn't stop our country from making laws, taking up most challenging situations. This 12th legal era India Conclave is really carrying this agenda forward. We have been meeting for more than 7 years. I've been here right from the day when we enacted the Insolvency and Bankruptcy Code, and we had very good interactions with global leaders and our India's place in the global community. So investing in India, we need a policy. Of course, we have a policy. We need to have a legislative roadmap, because legislative reforms are essential for translating a policy into action. Unless you have good law backing up your policy will remain only in paper, because many of the policy inputs require legislative implementation. Unless you have a legislative backing and a judicial support, your law reform is going to be a failure. We have seen that in many instances. One example I could cite was bankruptcy law. For more than 2 decades, we battled to put in the bankruptcy law reform process. Many attempts were made, 2-3 attempts were made, but we couldn't go through. But the task was assigned to me, we took it up, and there is a lot of skepticism that how are you going to do that? And it's not going to happen. They simply said it won't happen. Our finance minister then, Mr. Jaitley, he himself said, I am giving this task, you try your luck. We tried and we got it through with great amazement, and it went through like anything. I continue to defend the IBC in various forums because there is a lot of criticism about the code, about its failure, and all sorts of things. But I continue to defend it, and I have reasons for that. Now, law reform is essential for doing business, and industry, commerce, and investment can only thrive when the state policy provides a conducive business environment to stakeholders along with a robust dispute resolution mechanism. Since I was involved in this lawmaking process for quite some time, I can speak with some inside information. How does it happen? How does it happen? No, the present government for the past 8 years have undertaken many reforms which has been historic. I'll tell you why it's historic. Before I tell you why it's historic, I'll tell you what is the challenge of law reform. No, to reform the law, you will have a lot of resistance. Resistance is always there because people are suspicious about anything new. And they say, who is it? Who's behind it? Who will benefit? How are you affected? Law is always an infraction of liberty. You all know, ultimately it ends up regulation, it ends up with punishment, etc. So there is an old Spanish proverb which says, when there is more, there is of more. There is less, there is of less. So when you have more of law, you have less of liberty. But then we can't live without making law. So how do you do that? So law reform always meets with great resistance because people are suspicious, people who support it initially are skeptical, and it takes a long time. I only recite what our great political philosopher Machiavelli said. It must be considered that there is nothing more difficult to carry out, nor more doubtful of success, nor more dangerous to handle than to initiate a new order of things. For the reformer has enemies in all those who profit with the old order, and those and only lukewarm defenders and all those who could profit by the new order. This lukewarmness arises partly from the incredulity of mankind who does not believe anything new until they actually have experience of it. This is, in short, the state of law reform. The second part, apart from this resistance to change, is the law reform movement in India has not really taken off. I can say that because I've been involved in this law-making process and law reform. I was in the member secretary of the Law Commission for more than 3.5 years. So law reform in India revolved around doctrinal research. It depended upon accidents of litigation or political controversies where there is a need for some change in the law, and there is a scam, and then you have a law, you have a committee, etc. There is no systematic law reform. Law in action studies, empirical research, impact analysis are totally lacking. We cannot have reformation of law based upon anecdotal evidence and accidents of litigation. We have to have scientific basis. Jeremy Bentham, he propagated science. Legislation is a science. Properly drafted legislation can solve many of the ills. But on the side, I would like to ask somebody. Bentham said, the purpose of law is to increase the greatest happiness of greatest number. But I don't know which law increases the happiness of the member, because as a draftsman of the insolvency and bankruptcy code, I get abuses everywhere I go. People say, what sort of law you have drafted? So this is on the side. So what law does not increase happiness, it governs. Ministers and prime ministers are not here to increase the happiness, they have to govern. Happiness comes as a side effect. The law reform without empirical data, impact analysis is bound to be. It is not a real law reform. This has now changing. It's changing. We live in an age of big data, algorithms, artificial intelligence, as Dave Dodge said. Judicial process has to migrate and had to adopt in a big way. Not only judicial process, the dispute resolution organs, including all tribunals, arbitration. Because currently I am interested in the task of looking to the arbitration law. We implemented the municipal model in 1996 with a great transfer. And then we are still struggling to make India half of international arbitration. That was a dream. We had implemented it and went rolled off. We had brilliant lawyers and judges, but then nothing is happening. People don't want to come to India. Indian litigants are going abroad to Singapore and Hong Kong and Dubai to litigate, to arbitrate. What is the problem? How do we solve that? And let us see what we can do about that. Now the problem of law reform is lack of data. There is no scientific law reform. So there are three or four major measures taken by the present government which calls for mention. The first is the enactment of Central Goods and Services Tax Act of 2017. This is one nation, one tax. So this GST replaced multiple indirect taxes levied by the central and state governments, as such as excise duty, service tax, value-added tax, and others. It has brought in uniformity in tax structure across India, eliminating the cascading effect of taxes. No data. As I told you, legislations are enacted by Parliament. Very rarely, ministries who sponsor legislation, take any measures to see how the act is being working in practice. Law in action. Nobody bothers. There is no need to do that unless some litigation arises, something before the court. There is no systematic review of the working of the act. Only one act till the enactment of IPC had such a big structure, that is the CBDT and the CBS, indirect taxes, where they had data at hand. There's a tax research unit. They have data at hand. So they can tell you by touching which sector they can generate revenue, everything is on the fingertips, so it's easy to make the law and deal with it. This sort of mechanism did not exist for any other law because it required great machinery, collection of data, and an enforcement agency. It has never been. But Central Goods Services Act, being a revenue thing, it captures that. The second, I come to my own maybe, the Insolvency and Bankruptcy Code. The code is a jewel in the Indian statute book because for a draftsman, statute book is Bible. It is Bhagavad Gita because we live with the statute book because we draft the law before the computers came in. We used to write, type, read proofs. So it is a baby. I know each full stop, comma, etc. Normally, people don't read an act of parliament from top to bottom. Nobody reads it because the act is very opaque, it is very difficult to understand, and even judges and lawyers go only to the section and they litigate, argue and litigate. But as a draftsman, I have to see from top to bottom, from the formatting to the end. So it requires many times of reading, rereading, consultations. It is a very taxing profession, being a draftsman. So when this Insolvency Bankruptcy Code changed the whole process and whole setup because it has an ecosystem. As I told you, one day the revenue laws has an ecosystem to see the implementation of laws. Insolvency and Bankruptcy Code, the most challenging task, as Vajpayee was telling me, consolidation of all the acts and rules into one. So we try to repeal 14 enactments and bring them under a single code, codification. A single code will bring you access easy and make understanding easier for the consumers and users. The ecosystem we built around the Insolvency and Bankruptcy Code are excellent. First, we have the information utilities, and then we have bankruptcy tribunals, and then the bankruptcy code, and the resolution professionals. When we started this thing, and I appeared before the committee, parliamentary committee, when the bill was being examined by the committee, I was the first person to give the evidence. I was questioned by the members, you are creating something new. Where are you going to get the people? Where is the expertise in this country? Where will you bring them? I said, I think that should not deter us. It will happen. For everything, there has to be a first time. It will happen. So we have started it and we are moving ahead with all the pitfalls, negative things. We are progressing. For 7 years, the act has been enforced in 7 years. You can't judge whether an act of parliament is a success or failure. And tell me, how do you judge the success or failure of any act of parliament? On any basis? Where do you do that? But then in Insolvency and Bankruptcy Code, we have the data. No other act has data. Even Indian Penal Code has. You don't have such a ready-made on the touchable data. So you have this data, so you are able to criticize. And you know what is the aim of the act. People have different aims of the act. Even Parliamentary Committee mystified and said there is a lot of liquidation, there is a lot of haircuts, so the act is a failure. So there is no, you can't find out what is the act. You have to see the spirit of the enactment. How do you see that? So, Insolvency and Bankruptcy Code gave us a very brilliant example of how law reform should take effect. Now, then I come to defending the code later. The code is futuristic in design. It is futuristic in design and it can accommodate fast changing technological developments which have a lightning impact on the financial markets. Now we have tribunals all over the country, national company law tribunals, and we are trying to battle with the backlogs. Now when the code was enacted, the object was rehabilitation. It was meant not to be a recovery mechanism. Unfortunately, things went in a different way and things have crowded. Because there was no bankruptcy outlet before the act was enacted, then suddenly floodgates were opened and then it started flooding, and then we are having a deluge. Now the Mediation Act is coming. So the Mediation Act may give you some relief to the insolvency code. We hope so, do not know. So the Act has been notified, and I think they should have the infrastructure in place. There is a provision for online mediation, there is a provision for online service providers, etc. So mediation can go a long way in addressing the problems of personal insolvency, more than the corporate insolvency. Personal insolvency has not been implemented so far. It will be implemented at the mediation level also. So the second most important legislative thing which was introduced by the government was IDC. Then third is the enactment of the Commercial Courts Act. The Commercial Courts Act of 2015 is to fast track the adjudication of commercial disputes, and it facilitated the establishment of commercial courts and commercial appellate courts at the district levels and commercial division of the commercial appellate division high courts. So this went a long way in addressing many of the delays in solving commercial disputes. The special jurisdiction relating to commercial disputes is aimed at ensuring timely disposal of commercial disputes without straining the resources and capabilities of stakeholders. The subsequent amendments in 2018 to the Act an introduction of pre-institutional mediation and settlement for suits which do not contemplate any urgent interim relief. This is absolutely effect. For example, the Delhi High Court petitions challenging arbitral awards are being disposed of in approximately 400 days, which is far less in comparison to the earlier period of 1,445 days. And efforts are on to reduce this period further. Then we come to the fourth important legislative reform we are attempting is to the Arbitration and Arbitration Conciliation Act. With the enactment of the Mediation Act, conciliation is gone. The title is safe. What is the importance of arbitration? Businesses seek assurances of the prevalence of rule of law in the Indian market. They need to be assured that the rules of the game will not change overnight in an arbitrary fashion, and that commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant arbitration culture is essential. These are the words of Prime Minister Narendra Modi. So this is something which we are thinking of taking it forward. We are trying to solve the bottleneck. It may look very strange. Most of the problems, delays, etc. in Arbitration Act relate to our challenge of appointment of arbitrators. Is it necessary to waste time on this thing? Fully disputing the litigation, the litigation awards, then problem comes in enforcement of awards. All these three are bottlenecks you will address, I believe. And these are some of the important legislations that the government has taken up, and we will continue to address most of the challenges. I'm very happy to share some of my thoughts with you, and I congratulate Nagarti Raheza for organizing this conference and inviting me. Thank you very much.